Hey guys, welcome to today's Legal 101. This is a Thursday, so it's on land law. Now, my brother recently sent me a gazette notice that was issued by a land registrar in Nyandarua. Before I tell you what he had asked me about it, which may be of importance to you. It's important to say what was in the in the gazette notice. Now, basically, the land registrar was saying, person X, who is deceased, is the owner of this land parcel number XYZ. The magistrate's court has issued letters of administration to two people, namely, we'll call them Arnold and Judith. And the land registrar also said, I am informed that the title deed over this parcel of land is missing. So if there is no objection within 60 days of this notice, I will dispense with the production of this title deed and proceed to register forms LRA 39 and LRA 42, and the title earlier issued to the deceased shall be deemed cancelled and of no effect. So my brother wants you to know how this property will then be divided between these two. Okay. So this is what I told him first. That gazette notice only mentions the administrators of the estate of the deceased man. So there's a possibility that there are other beneficiaries to that estate other than Arnold and Judith. And their names would be in the grant of letters of administration. Then number 2, Form LRA 39 and Form LRA 42 are transmission forms. They are forms that are filled by these two administrators to transfer the property from the deceased name to their name, first of all, that's Form 39, and then from their name to the name of the beneficiaries, that's Form 42. And this can only happen if there's a succession process. Okay, there's an actual grant of letters of administration that has been confirmed. And this happens after the beneficiaries of the deceased person have come together, they have instituted the succession process, they are administrators, they have agreed on the manner in which property will be divided, and they are ready. Nobody is objecting to anything. Okay, and the court has understood them, and everybody agrees that the distribution is fair and just. Then I also told him, if two people are the owners of a title, okay, and it is not clear who gets what portion, the presumption in law is that they will hold the title as tenants in common, in equal share. This therefore means that if one of them dies before the property is subdivided between the two, the deceased person's portion goes to his or her beneficiaries or dependents in their own succession process. Okay? And the person who is alive gets to keep their share. But if the title says the property is held jointly, this is different from a tenancy in common, in that when one of the joint owners dies, all the property passes to the surviving owner. How? The surviving owner simply notifies the land registrar of the death of the other owner and applies for the removal of the name of the deceased from the title. Okay, I hope that helps you understand the various things I have mentioned. In case you want to go through a succession process, you may need to actually get the services of an advocate. If you want my services, reach out in the DMs. I know some people always institute succession process by themselves. And then in between, you will hear things like, I would like to ask the court to guide me. And the court is not in the business of guiding you on procedure. Okay? Which is where we have professionals like us who can guide you on procedure. Sema tu hutaki kulipa, ama pengine huna pesa ya kulipa. Lakini kama huna pesa ya kulipa, inabidi basi uelewe the rules of the court. Okay? So that is my contribution regarding today's Legal 101. Yes, see you tomorrow for tomorrow's Legal 101. Bye.